Thanks everyone for joining us. My name is Jay Huang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time discussing the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will send you all a visa guide, a comprehensive guide you can use as a reference to the visa types that will be introduced in this webinar. We will also send you a link you can follow where you can sign up for additional webinars coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we regularly do upload immigration law-related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case in further detail. So today, we are very lucky to have Kelly Weiner, who is the managing attorney of the firm with a wealth of experience handling cases in the visa categories that we will be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jay. So we're going to get started and just talk a little bit about some of the most common extraordinary ability categories, in particular the O-1A, O-1B, and EB-1A green card. So we have some, just basic overview information here. So the O-1A, is for people who have extraordinary ability in the sciences, education, business, or athletics. And it's a relatively high standard. You must be one of a very small percentage of those who've risen to the very top of your field in your profession. The O-1B has a few subcategories in it. So this generally is known as the category for people in the arts, and also for extraordinary achievement in the motion picture or television industry. So the standard for the arts is, somewhat lower than the standard for the O-1A, as opposed to a small percentage who's risen to the very top of their field. The standard is distinction. Which is defined as a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So when you have a situation where somebody may potentially qualify for an O-1A or an O-1B, if there is some flexibility, sometimes there's kind of niche fields, something that's become more popular, things like bartending, sometimes, there's an ability, tattoo artists, sometimes there's an ability to make an argument for the O-1B as opposed to the O-1A, and sometimes that can be favorable because the standard is a bit easier to meet. The standard for motion picture and television industry is a different standard, so that's higher. You reach a level of acclaim substantially above that of your peers. So moving to the EB-1A green card, so the O-1A and the O-1B are both temporary. So you can, get these visas and then you can kind of renew the visas as long as you have work in your area of extraordinary ability. The EB-1A is appropriate for people that want to live in the United States full-time and make the U.S. their home. So the EB-1A is for people with extraordinary ability in the sciences, arts, education, business, or athletics. So whereas we have 2 categories separating out, arts from these other categories between O-1B and O-1A, for the EB-1A green card, these are combined. So, if you're someone in the arts, you're going to apply under that same category. Similarly, if you're in business or education, athletics, science, everyone's going to apply under that category if they want an extraordinary ability green card. And the standard is very high for this category. We'll talk a little bit more about kind of some potential alternatives later in the presentation. But if you are interested in an EB-1A green card, it is important to recognize that It's a very, difficult standard to meet. It's appropriate for people who have, risen to the very top of their field, or in that small percentage, who have sustained national or international acclaim, and where their achievements have been recognized in the field of expertise, and the person is intending to continue working in this area when they come to the US on their green card. And so this is, for the O-1A and the O-1B, you can, kind of get these visas, in initially 3-year increments, then 1-year extensions, or potentially 3-year extensions. But you're only going to be able to get the visa granted for the length of time that you have, work that's, that's demonstrated in your petition. For the EB-1A, it's obviously, because it's permanent, it's a bit more prospective, but you would include kind of a statement explaining what you plan to do in the future. And then if you do have any kind of current documentation of what you plan to do, you would submit that as well. But it is important to note that in these categories, you will be required to demonstrate that you will be working in your area of extraordinary ability. So let's look a little bit more at the O-1A requirements. So for these requirements, you show either that you have received a major internationally recognized award, for example, a Nobel Prize, a Pulitzer Prize, or more commonly, people are going to show evidence that they meet at least 3 of the following on this list. So, nationally or internationally recognized prizes or awards, memberships and associations in your field for which you have to have outstanding achievements, published material about you or your work in major media or trade publications, original contributions of major significance, authorship of scholarly articles, a high salary, participation on a panel or individually as a judge, and employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. There's also another kind of catch-all category for kind of comparable evidence if you can kind of demonstrate that none of these categories are appropriate for the line of work that you're in. So that is something that's good to keep in mind. I'd say that, generally, in many areas, there's going to be, salary, for example, is one that's going to kind of apply across the board. But if you are in an industry that's very new, that has kind of different metrics, it may be something worth discussing, with your attorney as to whether there's kind of other comparable evidence, that could be provided if none of these really work that well with the area, that you have your extraordinary ability in. Also, just important to remember that, although 3 is the minimum, if you can meet more, it's, good to try to submit evidence for as many as possible. That being said, you don't want to submit weak evidence. So if you, for example, received an award for your college, that's really just a student award, the government really doesn't look very favorably on those types of awards. If you receive a general industry award while you happen to be a student, then that could be included. But you don't want to submit anything that's going to undercut kind of the totality of the evidence when the government looks at it to make the determination of whether you're someone who's risen to the very top of your field. You want them to feel that the totality of evidence shows that you are someone that has that extraordinary ability. And we'll talk a little bit more about how that plays out, what the standards are, as we go into additional slides. So now let's look at the O-1B. The structure for qualifying is similar. So either a major, award, given in the arts, or evidence of 3 of the following. And I'm not going to read them all, but you can see here on this slide that, ultimately these are more focused on, arts. So, things that would be relevant for people who are, performing, for people who are, putting together, productions that maybe, go to the box office. If you have kind of a lead starring or critical role in any, particular event or play or production. So ultimately, again, similar to the O-1A, you're going to want to meet as many as you can, but 3 is the minimum. And also, similarly, you want to make sure that the evidence you're submitting is, evidence that shows that you are someone who's achieved distinction, that's, met this high standard for showing extraordinary ability in your field. All right, so what are the differences between the O-1A and the O-1B? So as we kind of described, the fields are different. So O-1A is going to be for science, education, business, or athletics, and O-1B is for the arts or motion picture or television industry. Again, though, if you are in a field, especially kind of a new or emerging field, where it's not necessarily, very clear cut exactly where you fall, it may be worth, discussing with your attorney, to see if there's kind of some niche, that you can fall into, or some argument perhaps that you might qualify under the O-1B, again, because that standard can be easier to meet. And so when we look at those standards, O-1A is going to be one of the small percentage who's risen to the very top of their field. And O-1B for the arts is distinction, high level of achievement, evidenced by degree of skill above that ordinarily encountered, or for motion picture and television, a level of acclaim substantially above that of your peers. When it comes to how long the visas can be issued, the rules are the same. So you can get an initial visa for 3 years, an initial approval for 3 years, and then you can get an extension, for 1 year. However, if you're in a situation where, you're not just kind of continuing the same itinerary, but you actually have a new itinerary of projects, or you have a kind of a new employment contract, then you can try to make the argument that you should be given another 3 years. The government's not always consistent about granting this, but it's certainly worth asking, as there is an argument that, that you should be granted an additional 3 years if you have kind of a new engagement, a new set of projects, a new itinerary. Can your family come to the US? So yes, your family can come on dependent visas. That would include your spouse and any unmarried children under 21. Your children can go to school, your spouse can go to school. They can also just reside in the US with you. Unfortunately, they are not, neither your spouse nor your child is permitted to work under the O dependent visa. So that is something to keep in mind. And another thing that's, helpful, I think, to know about the O-1 is there's no kind of time limit on how many times you can extend the O visa. So for some visas like the H-1B or the L-1, there's limits, on how long you can continue to extend the visa. That's not the case for the O. You can continue to extend it as long as you meet the criteria and you continue to have this, extraordinary ability work available to you that you can demonstrate to the government. All right, so the EB-1A green card. So let's talk a little bit about the standard for how these are adjudicated. So the requirements are very similar to the O-1A and O-1B. So it's the same structure, either receipt of a major internationally recognized award or meeting 3 out of the 10 criteria. The wording of the EB-1A criteria are slightly different, to incorporate both the arts and business, science, athletics, education. When we look at how USCIS will approach this, the first step is they're going to look at the evidence to see, okay, does this meet the plain language of the regulation? So if the regulation says, proof of, a high salary, or proof of membership, in a professional association that demands outstanding achievements of its members. So first they're going to see, okay, great. Do we see that this person, is a member of a professional association that has that, requirement for outstanding achievements? And then in the second step, they're going to look at the evidence in totality. So, they say, okay, under the regulations, at least 3, evidence has been submitted for at least 3 of these criteria. And then they're going to look at it and say, does this, indicate that the person is someone who's risen to the very top of their field? So it's really thinking about the quality of the evidence. So that's to say that, many times kind of O petitions or EB-1A petitions can be very long, include lots and lots of documentation. But when you're including evidence, you don't want to just include every single thing. So you don't, even if you've won tons of student awards, you don't want to include all of those student awards. It's actually going to weaken your application when you get to that totality analysis, when they look at it and say, okay, well, we see 3 really strong awards, and then we see 10 student awards. That is really not going to help you. It'd be much better to include more evidence explaining why those 3 awards you won in your career are so prestigious, to have letters from experts in the field, commenting on how difficult it is to achieve, that level of acclaim that you would, win those awards. So, more is not always better, and quality is going to be better than quantity when it comes to these, these types of applications. So now we're going to switch gears a bit. As I mentioned earlier, there's, the EB-1A, is something, a green card that's available to people that have risen to the very top of their field can be a very difficult standard to meet, particularly if people are kind of new in their field or just starting out in their careers. But there are other potential green card options for people who are doing, really remarkable things in their field and maybe don't feel like they've met that EB-1A standard yet. The EB-2 national interest waiver could be a good, thing to consider. So GA is going to walk us through the criteria for that green card.
All right, so the national interest waiver EB-2 green card pathway could be a great option. So, and really you can apply for the NIW from any field, right? So not only is it available for engineers and scientists and business people, also you can be approved for the NIW if your work in your field will result in national or global, advancements to your field as a whole, and we can prove that your work in the United States will prospectively broadly enhance cultural enrichment or societal welfare. So a broad variety of endeavors could qualify for the NIW, so it's definitely an option you can consider. Now, how do you qualify for the national interest waiver EB-2 green card then? So first, the applicant needs to meet the EB-2 threshold requirement, right? The individual. So there are two ways to meet the EB-2 threshold requirement. First is through showing that the individual has an advanced degree, which is defined as a master's degree or a higher level. And also an equivalent of a master's degree can be met by showing a bachelor's degree in your field and 5 or more years of progressive work experience following the bachelor's degree in your field. And what do we mean by progressive work experience? It means that your duties changed over time to include more complex duties, to include more seniority in the responsibilities that you took on. Now, one thing to note, if you went to a foreign university for your when you were obtaining your master's degree or a bachelor's degree, if you're using your bachelor's degree, if it's a foreign degree, then it is very important to also obtain an educational equivalency report that confirms that the foreign degree is actually equivalent to a US degree in that particular level. The other way you can meet the EB-2 threshold requirement is by showing exceptional ability. And you can show that you have exceptional ability in the sciences, arts, or business. And to show exceptional ability, you do need to show that you can provide evidence under at least 3 out of the 7 criteria that is listed here. For example, even if you don't have a master's or a bachelor's, you can show an official academic record showing that you have any degree that is related to your field. You can also show 10 years of full-time experience in your field. You can show that you have a license to practice in your profession. You can show that you are a member of professional associations in your field. And importantly, you can show that you have obtained recognition for your original significant contributions to your field, which can be, for example, if you publish original research that has been cited, if you develop new technology that has been patented, or if you are an artist, if you have, put on a particular creative production that has received positive critical reviews. All of those things can be considered contributions to your field, and you can back this up by testimonials from relevant leading experts in your field and other evidence of such a claim. So the goal of meeting the exceptional ability standard, one thing to note is that it is a lower standard from what we discussed as extraordinary ability as relevant in the EB-1A context, right? So exceptional ability is defined as holistically a degree of expertise that is significantly above that is ordinarily encountered in the field. That is definitely a lower standard than extraordinary ability, which is defined as one of the small percentage that has risen to the very, very top of the field. So definitely meeting the EB-2 threshold is a more attainable standard for many people. Now, let's say you qualify under the EB-2 threshold. The next step, and this can also be a challenge, is to demonstrate that you do qualify for a national interest waiver. And the reason why this is necessary is because normally the EB-2 category, you can approach this in 2 ways. You can have a US-based company sponsor, an employer that is offering you a job, and that employer could go through what is called the labor certification process, which is a process of testing the labor market to show that there is no one else who has the minimum credentials to fill that job. Now, that process, however, can be time-consuming, and it also can be a complex process. And also, if there is someone else who has the minimum credentials that is required for the job, you will not be able to benefit from this process. However, the national interest waiver, if you qualify for the NIW, you do not need a U.S. job offer. You do not need to go through that sponsorship labor certification process. So individuals are allowed to self-petition for a green card under the EB-2 NIW category, which is what makes it often very attractive category for some people. So how do you qualify that how do you show that you qualify for the national interest waiver? You will need to meet what is called the three-prong matter of Danaher test. There are three factors that you should show evidence under. The first factor is that you need to prove that your proposed endeavor has both substantial merit and national importance. And what does this mean? A proposed endeavor means your plans of working in the United States. What you plan to do in the United States can be in a wide variety of fields. As I mentioned, it can be in business, can be in health, education, science, technology, and culture, societal welfare, and the arts. Endeavors that aim to further human knowledge in those key areas. And for example, endeavors that result in medical advances, endeavors that result in improvements in civil engineering processes, manufacturing processes, for example, those are typically seen as endeavors with substantial merit. If an endeavor involves typically a strong economic impact, that is also a very positive factor for a finding of substantial merit and national importance. Really, the important question to ask here is, what is the future impact of your work? What is the prospective impact of your work? And how will this benefit the United States? And benefit to the United States can be defined in a variety of ways. As I mentioned, it could be, advancing U.S. competitiveness in a critical sector such as technology, AI, or 5G or things like that. But it also can be in the realm of cultural enrichment, significant improvements in societal welfare. So there is a variety of endeavors that can qualify for the NIW. And frequently, those arguments are supported by copies of government reports published by U.S. government agencies that explain why those areas are important to the government. And this can be a key form of evidence that supports substantial merit and national importance. The second prong for demonstrating that you meet the NIW criteria is that you yourself, the individual applicant, is well positioned to advance the proposed endeavor. Now here, the inquiry is on the individual's own credentials itself. So this can involve an individual's record of education, relevant degrees, relevant coursework that they have obtained, professional experience that is relevant to the proposed endeavor in the United States. And really what the government is looking for is a record of success in previous related projects. Frequently, we would support this prong with detailed expert letters discussing some mini case studies from your most impressive projects in the past that has resulted in advancing the field in some way, and really explain how this makes you the ideal candidate to realize your plans in the United States. The third prong is that there must be a showing that on balance, it would be beneficial for the United States to waive the requirements of a job offer and thus of a labor certification for this particular individual. And there are a variety of ways we can argue this. We can rely on prong one, national importance, and really emphasize the broad systemic benefits to the field as a whole that your work in the United States can bring. We can also rely on prong two, which is we can talk about your unique know-how and experience that other U.S. workers with minimum education and qualification experience requirements simply do not have. And third, there could be special considerations. For example, if you are an entrepreneur, we can talk about substantial economic benefit to the United States coming from your business project, such as U.S. job creation and generation of tax revenues for the government. And those benefits could outweigh the ordinary benefits of labor certification, which is preserving the U.S. labor market for one other worker. All right, so we can move on to the next slide. All right, what is included in expert opinion letters? So expert opinion letters are a very important element of both O-1 visa applications, EB-1A applications, EB-2 NIW applications. The purpose is a little different. So for example, for the EB-1A and O-1A categories, you would want the experts to confirm that you do have extraordinary ability in your field and is well known, such that you have sustained national and international acclaim in your field. Typically, the letters would focus on your past achievements and really talk about why those achievements were important and outstanding in your field, and how this has been received broadly by peers in your field. With regards to EB-2 NIW applications, some expert letters can emphasize the national importance of the applicant's proposed endeavor. And what can be really helpful is getting a letter from an official in a government agency that is covering the field. For example, if you're someone who's working in agriculture, getting a letter from an official at the USDA talking about the proposed endeavor and what positive impacts it can have can be a very powerful way to strengthen your application. Other types of letters can be similar to the O-1A, EB-1A letters in that the letters could focus on developing examples of why the applicant is well positioned to develop their proposed endeavor in the United States in terms of their unique skills, their unique experience, and the previous record of success that they bring. So, for example, this type of letter can be written by a previous employer, for example, if the applicant has worked with a leading corporation in the field and their work has resulted in widely used patented technology, for example, that can be a very powerful case study to develop and can support the argument of a record of success in that particular field. So who is writing the letter? It is very important to get the expert letters from figures in the field that are leading figures who typically have a wide decades of experience. And usually we would also add the expert themselves, full curriculum vitae with the letter to really show the USCIS the credentials the expert has such that the testimony becomes more reliable. There are different types of letters depending on the relationship of the expert to yourself. So we recommend that the application include a mix of independent experts and inner circle experts. So independent experts are people in the industry who may not have directly worked with you, but they know you because you are well known in the field for an O-1A or EB-1A petition. Such that they know you through your work, right? So the independent experts can talk about your field, talk about your reputation in the industry, and confirm that your abilities are outstanding in your field. By contrast, inner circle experts are people who have worked with you and can speak to your achievements in the past in more detail. For example, in the example that I talked a little bit before, if you have worked in a company developing a broadly commercialized technology, for example, someone who you've worked with, the supervisor in your previous company, can provide a testimonial letter to discuss those cases. Now, as I mentioned a little bit before, the specificity in the discussion in the letters is very important. So what is the content of those letters? Specific examples of your work is important because those examples will support, for example, why you are an extraordinary figure in your field or why your project in the United States will have national importance. So things that you will add in those letters would be questions such as, what exactly did you perform? What problem or limitation was the industry facing? How did you solve this problem in an original way? Why was this significant? How was your work shared with other experts? And how was this work received by other peers in your industry? All right, so we can move on to the next slide. What category should I apply for? So there are quite a bit of considerations we can discuss here. So the first question is, do you want to stay in the United States temporarily or permanently? Right? So as Kelly mentioned earlier, O1A, O1B are non-immigrant visas, which means you will be able to travel in and out of the United States as much as you wish, as opposed to a permanent residency option. Permanent residents, U.S. green card holders do have some requirements that they need to follow in order to maintain their permanent resident status. So if your goal is really to maintain your permanent home in a different country and simply come to the United States on a temporary basis to do your work, whereas as opposed to living and working permanently in the United States, the O1A or O1B visa could be a better option. Now, the EB-1A and NIW are both green card options, which is really appropriate for people who want to live in the United States permanently. And once you get the green card, this will also open up the pathways to citizenship. So this can be a great option for people who have their eyes on that future goal. Another consideration is, do you have a U.S. employer or agent, or do you want to self-petition? Now, the O1A and O1B visas do require a U.S. employer or U.S. agent, which is either a U.S. legal entity, a corporation or an LLC, for example, or a U.S. person, a U.S. citizen or U.S. permanent resident who will serve as an agent. Now, the EB-1A and NIW does not require that. The foreign national individual can serve as a self-petitioner for those green card petitions. So you do not need that U.S. petitioner to participate in the process. With regards to family considerations, as Kelly mentioned earlier, for a holder of an O1A, O1B visa, the spouse and children can join on a O3 visa. Children under 21 can come. However, the spouse is not able to work under the O3 dependent visa, although it is possible to study in the United States. As by contrast, for the EB-1A and NIW, for these green card options, one spouse and minor children can apply for green cards along with the primary applicant. And if the applicant is in the United States and applying for an I-485, which is the adjustment of status application, it is also possible to apply for a work authorization, the employment authorization card, the EAD, and a travel authorization that will allow the applicant to work for any employer once they have the EAD, and also travel in and out of the United States once they have the travel authorization. The spouses and children can also apply for those benefits alongside the primary applicant. All right, so we will move on to the next slide. Considerations when moving from a non-immigrant visa to a green card. So the first thing to consider is that the qualifications are a little different. So it is important to note that although the regulatory language is quite similar, requiring extraordinary ability, practically it is a higher standard to qualify for the EB-1A standard as opposed to qualifying for the O1A or O1B. And this means, in other words, that just the fact that you were approved for an O1A or O1B visa does not mean that you automatically qualify for the higher EB-1A standard. So, and if you are on an O1B visa, that can be a particularly a higher jump because the O1B visa only requires a distinction in your field, whereas the EB-1A requires that you have reached the very, very top of your field, be one of the small percentage that have reached the very top. So if you are already on an O visa, and if you're looking to apply for the EB-1A in the future, a strategy that you can have is to really build up your profile and try to meet as many of the evidentiary criteria as possible with high quality evidence that could really help you with the EB-1A. So definitely bolstering your profile with those relevant forms of evidences, high quality evidences could really be a good strategy for the long term. Now let's consider a timing issue. So timing becomes an important issue if you are already in the United States on a different type of visas, because some types of visas are harder to extend or subject to more scrutiny once you apply for an I-140, which is the underlying petition for eligibility of the green card, or if you file the green card petition itself. So let's talk about an example. The TN visa is a visa that is typically scrutinized quite strictly for non-immigrant intent. And in order to qualify for an extension of the TN visa, renewal of the TN visa, you need to continuously show that your intent to work in the United States is for a temporary time period, and that you do not intend to, become a permanent resident of the United States. If you have filed an I-140, this can affect these types of applications. Now, there are certain types of visas called dual intent visas that are not affected by immigrant intent, and these are the H-1B and the L-1. And to a degree, the O-1 is also much more lenient in terms of being affected by having an I-140 filed, for example. So definitely speak to your attorney if you're already on a non-immigrant visa and if you are planning to file an I-140 in the future. Now, family considerations, that can also be important. For example, for the EB-1A and EB-2 NIW option, this allows spouses and minor children to obtain green cards also as derivative beneficiaries. But for children to qualify, they need to be under 21 and unmarried. So it could be an important consideration to file the petition early to avoid children aging out and not being able to benefit from this category. All right. So the last topic we'll discuss today is, are extraordinary ability categories available for entrepreneurs? And the answer is yes. Entrepreneurs can potentially qualify for the O-1A, EB-1A, and EB-2 NIW, provided that they're able to present the evidence that is responsive to the eligibility criteria. And let's consider some specific advantages. For the EB-1A and EB-2 NIW, the self-petition is possible, which means the foreign national themselves can act as the petitioner. This can be advantageous for entrepreneurs because this eliminates the need to get a US-based petitioner to act as the driver for the petition. Now, matter of DANISR, which changed certain aspects of the NIW adjudication standard, did make NIW a much friendlier category for entrepreneurs. And in 2022, there were updates to the policy manual that USCIS uses to look at NIW cases. The types of evidence that is going to be helpful has been expanded. So for example, now entrepreneur applicants for the NIW can use letters from investors, talking about the product and its potential, for example. Entrepreneurs can submit tax returns showing a history of revenue generation and W-2s showing a history of hiring for the company to support that they're well positioned to continue their business project. Participation in incubators, accelerators, and having won investments from third-party investors can serve as supporting evidence for an NIW case for an entrepreneur. So those types of new guidances really make NIW a more approachable category for many entrepreneurs. Let's briefly discuss the O-1A option. If you're an entrepreneur and if you have a U.S. entity that either you own, it is also possible for that separate corporate entity to be the petitioner that's driving your petition. If you're considering using that option, definitely speak to us. We can talk more about the specific considerations to be careful for in that kind of scenario. Okay, so now we'll move on to questions and answers. It appears we have one question here. We are experienced musicians in a home country, and we are retired 2 months ago. We play for the State Opera and Ballet Orchestra of Turkey. We are not popular in the country or internationally, but we have experienced. Is that enough for the, I would say, O-1B or the EB-1A, definitely schedule a consultation with us. We would love to take a look at your resume and talk in a little bit more detail about your experiences. That will give us a little bit more detail on whether any of these criteria could work for you.
Yeah, one thing I will say though, is just, that you mentioned that you're retired. So, kind of as discussed earlier in the presentation, this is, these visas are for people who are coming to actively work in the United States, and continue to work in their areas of extraordinary ability. So, if someone kind of was, extraordinary in their field, but has since retired, the O-1A or O-1B or EB-1A are not available for people to come retire to the United States. They are for people who plan to continue to work in their field of expertise.
Definitely. Great point. All right. So I don't think we have any other questions that came in. Yeah. So thank you everyone for your time. Thank you, Kelly. And we will all see you next time.
Thank you.